Thanks, Nancy. As Nancy has mentioned, both Helen and myself are presenting today from the Goodwille HR team. For those of you who don't know us or aren't familiar, I'm the HR manager at Goodwille, and Helen is a senior HR advisor in my team. In terms of what or who Goodwille are and what we do, again, most of you hopefully on this webinar will be familiar with that, but we have been operating for over 25 years. We've helped more than 2,000 businesses across a range of industries to expand or scale in the UK. Effectively, Goodwille are a one-stop shop. We offer a complete solution for companies who are looking to expand, grow, scale in the UK. HR, of course, are one offering that we give, but we also have corporate legal, finance, payroll, and virtual office. In terms of the HR department, back to Helen and I, we offer assistance for the full employee life cycle. So again, many of you will be familiar with the department already, but any assistance that you might need from initial onboarding of employees, scoping out packages through to employee relation matters and exits, we can help you with all of that. And we also can help you with secondments and sponsorships. So where you have global mobility matters, you want to move your individuals from overseas to the UK, then we can help you with those occasions as well. In terms of what we're covering today, this is our usual biannual employment law update. We are going to be focusing on what further developments are going to be coming in relation to the Employment Rights Bill. So specifically today, we'll be looking at changes to statutory rates, changes to unfair dismissal, enhanced protections for pregnancy, flexible working, leave arrangements which have a slant on family care, 0-hour contracts, fire and rehire, trade unions, third-party harassment and immigration. So we've got quite a lot to get through this morning. I'm going to kick us off in terms of pay rate changes. So I'm not going to spend too much time on this area because ultimately the amounts for statutory payments are what they are and they will be what you need to pay. But we do have, in terms of current rate, our existing national living wage and minimum wage for workers aged 21 and over is currently set at £11.44 per hour. That will be increasing to £12.21. Then we have the national living wage for workers between 18 to 20 years old. That will be moving from £8.60 an hour, jumping to £10 per hour. So actually there's I think the stats are around, there's like a 6% increase actually, which is quite significant, we feel, for these groups of people. Then we also have the young workers rate. Now that is for workers aged 16 and 17. It's not on the slide specifically, but those rates do apply to apprenticeships also. And that will be increasing from the current rate of £6.40 per hour to £7.55 per hour. And then we have family leave rates. So when we talk about family leave rates, we mean things like maternity pay, which is aside from the first 6 weeks where you need to pay 90% of average weekly earnings, but the lower maternity pay rate after that point. Also paternity pay, shared parental pay, and statutory parental bereavement pay. That is currently set at £184.03 per week. From April, that will be increasing to £187.18 per week. And then we also have statutory sick pay. So we will be talking a bit more about some additional reforms on this later. But statutory sick pay as it stands today is currently £116.75 per week. And that will be increasing to £118.75 per week. Next slide, please. So we also have some increases coming to employers' national insurance contributions. There's been quite a lot of focus on this recently. So that will be increasing from 13.8% to 15% from April 2025. That's going to maybe impact some businesses more than others perhaps, but overall your payroll will increase. Make sure that you have your payroll systems ready. You know, do plan for the inevitable employment costs for the business and an increase in that. And then also another way that you could consider tackling those increases would be thinking about maybe offering salary sacrifice as a default for your pension contributions. So on that portion of salary which is being sacrificed, you could make some employer NI savings in that respect. It isn't, of course, going to solve the overall payroll increase. That is still going to happen, but it may help a little bit to limit that. So if you are interested in looking at salary sacrifice for the business, do reach out to Helen or I. We can help you review your current policies on this, put some in place. But a lot of employers maybe are looking to move to a salary sacrifice structure from next month just to help with those increases. And I'll pass you to Helen to talk about unfair dismissal right changes.
Thanks, Jacqui. So one of the big changes that is expected from autumn next year is the change in day one rights and unfair dismissal rights. So just a brief reminder of what we have at the moment. So employees must have worked for their employer for at least 2 years to bring any kind of claim for ordinary unfair dismissal, and currently there's a 3-month window in order to make an employment tribunal claim. This, although it's not set in stone at the moment, is likely to change to a day one right. So a day one right to unfair dismissals, and we are expecting that there will be an initial employment period, and that's expected to be around 9 months. And the window in order to make an employment tribunal claim is likely to be extended, and that will be a 6-month window rather than a 3-month window. So this is a really, really big shift in how we operate at the moment, and how we're going to look at moving forward and what it means for you. So it's likely to mean that there will be some changes in terms of how you operate in the business and the risk that you will experience when you're looking at potentially dismissing employees. We can have the next slide, please. So as I mentioned, what does this mean for you? So it really does mean that there is likely to be an increased risk in termination claims. It's really, really, really important that you have a robust process in place. So have a look at what you currently do for new starters, so probations. Look at your performance improvement plans and appraisal processes, and it's really, really key that this needs to be documented. We see a lot of clients at the moment coming to us and talking about exiting individuals, and these things haven't been documented, or there's been an extremely light touch process, and there's going to be a need to have a really big shift from autumn next year to make sure that robust processes are in place for these things, and that it's been documented and that you can evidence that these things have happened. As I've already mentioned, there's going to be expected to be a 9-month statutory probation period. So currently there's not, in law, a prescription of how long probation periods need to be. So that's expected to go through as a 9-month period, but there's consultation that will happen on how long that's likely to be. So the things that you can really focus on now is getting your line managers in some good habits. So making sure that meetings are being documented, making sure that they're giving clear feedback to their employees, and having a look at having those difficult conversations sooner rather than later. So that might mean having discussions with underperforming employees now. Again, Jacqui and I do have clients that come to us where either those conversations haven't been had or it's very, very light touch at the moment. So it's really, really key to have your line managers some good habits and starting. The other thing that you can start looking at is your recruitment and induction process. So reviewing what that looks like. We really strongly recommend that you have at least 2 stages within your recruitment process, 2 sets of interviews with possibly, different groups of people and looking at who you're going to bring into the business, and also thinking about safety profiling tools and what other tools in your box do you have in terms of not just basing it on 1 or 2 interviews, having a complete process before someone joins you in the business. And then also looking at your induction. So once someone starts with you, what does that journey look like? Making sure that you have an induction plan for them, again, making sure that's documented. How are you tracking the training that they're being given? And you want to set these people up to succeed. So making sure that they're having the appropriate training and induction process for you when they start within your business. Next slide, please. There's one other point that I just wanted to cover off in this particular piece, and that was around collective redundancy rule changes. So the proposed changes are going to be that the one establishment rule will be removed. So at the moment, you can look at different spaces, different offices, different factory settings to be one establishment. But the proposal is for that to be removed. Initially, it was announced that any redundancy for across all businesses, if it's more than 20 people, it would initiate a collective consultation process. Now, they're looking at those rules again and putting some more wording and fleshing that out in terms of what that might mean in reality going forward. So they are proposing that it will either trigger when it's 20 or more, or whether it's in meeting another threshold. So that another threshold hasn't been defined in fully yet. I'm expecting some more announcements on that. But it might be a percentage of your establishment as a whole and meeting those sorts of triggers. So just as a recap, at the moment, you can have a look at single establishments, so whether that's an office or a factory, and whether that's 20 or more redundancies. But going forward, it's likely that you either need to look at the business as a whole, and if it's 20 or more, or there might be a particular trigger. So if it's a percentage of your employees that you're looking to let go through redundancy, at that point, you would initiate collective consultation. And I'll say exactly for the next piece.
Oh, I think we've got
oh, sorry, one more. So just to recap on what does that mean, as I've mentioned already, you really need to have a review of your probation process, your induction processes and recruitment processes, particularly around induction and probation. They need to be documented, and then also have a look at what your training needs are for your managers. So how are they going to manage probation processes? And as I mentioned, it's really, really key that these are documented. So have a look at what you've already got and set yourself up for what's expected for October or autumn next year, because these are really, really big changes in terms of the risks to businesses and how to exit individuals.
Thanks, Helen. Okay, so in terms of enhancements or enhanced protections for pregnancy and new mothers, we do have existing protections against dismissal of employees who are on maternity leave or recently returned, or dismissal for reasons related to pregnancy. So this is all protected under the Equality Act anyway. But at present, there is minimal specific protection for new mothers. So we did have some updates that were introduced in April last year, which gave individuals who were returning from family leave some increased protections, which were lasting for 6 months after return to work from that family leave. And this was mostly around protections from redundancy, really, and selection for redundancy for, from the point of 18 months from the commencement of that maternity leave. The proposed changes which are coming in, so the bill is contains proposals to strengthen protections for pregnant employees and returning mothers. The timescales are not set out, so the bill is very vague on this point, but we are expecting that this will also be for 6 months after a return to work, like it is now. But remember, we are looking for an increased increased set out of protections, and that is, again, the bill is very vague on that. So we need to await further regulations to be drafted to understand what this practically will mean for the business. So in terms of what it will mean for your business, nothing immediate. So we don't need to start changing policies or anything just yet, but do be aware that there will be sort of further protections coming through, and also making sure that managers are aware of the existing protections that we do have, particularly around redundancy, because we do have, again, a lot of clients that come to us with, you know, problems where they maybe are looking to move team members on who are returning returning from maternity leave. It is really important to remember that it isn't impossible to terminate employees who are on maternity leave, who are returning from maternity leave or pregnant. But the usual requirements would still apply: a fair investigation and processes if you have a performance or a disciplinary matter. And as I've just briefly touched on, it is quite a complex topic, but where you do have a redundancy process, under the current legislation, pregnant employees or returning mothers do have enhanced protections for up to 18 months from the start of their maternity leave. So effectively what that means is, if you have a suitable alternative role, they have priority over other colleagues for that position. So do please bear that in mind. I know that it's maybe not common knowledge with a lot of our clients that do come to us with the similar scenarios. Where there is a genuine business case where you need to remove a role and all employees are to be made redundant for that post, or you have a standalone role which that pregnant or returning mother occupies, then redundancy can still happen in that instance. But do please speak to us if you've got any issues in this particular area. I'll hand off to Helen to talk about flexible working.
Thanks, Jacqui. So I wanted to talk a bit about the changes that are coming in terms of flexible working. So just again, as a reminder of what we currently have in place, employees can make a flexible working request twice a year, and they need to be handled in a reasonable manner. And requests can be refused for one or more of the 8 set reasons. So that's what we currently have. But there's going to be a significant shift in how businesses need to review and look at flexible working requests going forward. So you would still need to be able to handle it in a reasonable manner. We recommend that you meet with the employees to talk about what their proposals are and how they can be incorporated within the business. But the big shift is about if you decline the flexible working request, you must provide a clear reason when refusing requests. So you can still refuse a request, but you have to have a clear reasoning and explain it in writing to employees. So what we're really encouraging people to do is to look at what your current policies are, and you will need to update those going forward. You'll also need to consider how managers do they have the skills in order to manage those on flexible working? Is there any skills gaps or upskilling that you need to do with your managers on this? But also, we feel that it's a really big shift in terms of mindset. So we find that clients often come to us with a default of, I want to decline this request, it's not going to work, and we want to reject it, even before they've met with the employees. But what we really think needs to happen is a shift in mindset. So going into these in actually how can we make it work? If we can't make it work with what's been requested, what other options are there on the table that we can present back to the employee in terms of meeting halfway, or just really thinking about how we can go into this with a positive. How can we make this work, or what other arrangements can we do that are flexible in order to support this employee? So you can still reject them going forward, but there is a definite shift in employers will need to explain in writing why it's being rejected. And we're expecting that there's going to be quite a focus on this going forward. We recognise that, of course, there are some industries where flexible working just might not be possible and might be more difficult. So if you have employees working remotely, or if they're more office-based, there tends to be more flexibility in terms of flexible working, but in some environments, it's just not so it's not taking away the ability to reject flexible. It's just that it needs to be documented and there needs to be a clear reason given. But it's really the shift in mindset in terms of how can we make this work rather than the default of it's to be rejected and it's just not. So what this might mean going forward, we're expecting there might be an increase in the requests when this change happens. As always, the decision making needs to be fair and consistent. Whether you've got one person applying, multiple people applying, you need to make sure that it's fairly applied across the business. We do recommend that trial periods are put in place for flexible working arrangements. So that could be for a 6-month period to see how things settle down, see whether it's going to work or not. And it's really key to consider going forward. As I mentioned, you'll need to have a look at the policies that you can place and updates in for those. Again, I mentioned already about management training. So are your managers equipped for remote working or flexible working? We've already talked a bit about moving away from the immediate reaction of declining, embracing flexible working and being as open-minded as possible, and that some industries and sectors it makes it more difficult or impossible. And so it's not going to work for everyone, but the mindset should be in terms of embracing flexible working.
Okay, thanks, Helen. So in terms of leave arrangements, I did mention at the start of this webinar that there is a key shift in terms of changing leave arrangements with a family or carers focus. So there's a few new introductions here. First off, we have parental leave. So the current situation for parental leave, for those of you who don't know what that is, parental leave is not used in the context of a birth or adoption of a child. This is where an employee can take up to 18 weeks leave up to the age of their child's 18th birthday. It's unpaid, it's used very rarely in our experience. The concept or the purpose of this is to look after the child's welfare. So spending time with your child, whether that be to look at new schools or settle your child into childcare. There is a qualifying length of service currently of 1 year to be able to request this leave. And then we have paternity leave, where this is used in the context of a birth or adoption of a child. So where you have the father or parent be in this setup where there is a birth or adoption, then an employee can take 2 weeks of leave paid at statutory rates. So we went through the statutory rates earlier. And of course, a business can enhance the payment from that statutory rate. But there is currently a qualifying period of 24 weeks of continuous service required by the qualifying week, which is 15 weeks before the due date of the child to be able to receive payment for statutory paternity leave and pay. So the changes to these two types of leave will become day one rights rather than having the 1 year and 26 weeks qualifying period that I've just spoken about. And then we have parental bereavement leave. So currently, a few years ago, we had parental bereavement leave that was introduced in the case of the death or stillbirth of a child. And this is in the context of pregnancies which were 26 weeks plus gestation period. So currently there is, as a reminder, there is no paid entitlement for bereavement leave in any other sort of relationships to parent-child. So at the moment, that still hasn't changed. We're talking specifically about statutory parental bereavement leave here. But parental bereavement leave is paid at 2 weeks statutory rate. Again, we discussed that earlier. The changes that will be incoming, we expect that there will be an extension to bereavement leave. So the details of the relationships that bereavement leave will cover have not been defined as of yet. But we are expecting that bereavement leave in the context of losing a child will remain at 2 weeks, but other bereavement leave is expected to maybe be 1 week of paid leave, and that is expected to be at statutory rate, the same as what the parental bereavement leave is paid at. Also, very recently, and it's quite fresh news, the government have announced intentions to change the bill to recognise miscarriages of pre-24-week gestation period. So there will be provision expected to be included within the bill for time off for pregnancy loss, but it's not clear how long that will be for. It's not clear when there will be any payment for it, but there is definitely commitment to that. So good news, because now, you know, when it comes to bereavement leave, there is no set parameters for business to give any specific time off. It's the legislation is quite fluffy in that respect. We also have changes coming for sick pay. So currently sick pay is paid from day 4. We have 3 waiting days before there's any payment for this that kicks in. We are expecting that statutory sick pay will be paid from the first day of sickness, and there will also be changes to the lower earnings threshold for statutory sick pay. So I believe that's currently set at £123 per week that an employee is required to be paid before they are eligible for statutory sick pay. But we don't know when that's going to come in. We were told maybe late spring, but we haven't got any dates on this yet. So, but of course we'll let you know when that takes effect. We also have changes to carers leave. So employees currently have a day 1 right to 5 days of unpaid leave to give or arrange care for a dependent. Now the parameters for being eligible for this carers leave are where you are caring for someone with a physical or mental illness or injury, which means that they're expected or need care for more than 3 months. If they have a disability as defined under the Equality Act, or care because of their old age. And currently this leave of 5 days can be taken once every 12 months, and it can be taken as split days or it can be taken as a 1-week block. There is no confirmed change, but there is a review on unpaid carers leave to consider introducing a right to paid leave. Where it's unpaid at the moment, there will likely be a statutory rate introduced for when someone is taking this leave. And then the big one is we have the Neonatal Care Leave and Pay Act. So that will be now coming into force on the 6th of April this year. And will apply to babies born on or after the 6th of April 2025. So employees who will be eligible will be parents of babies who require neonatal care for at least 7 days, which start within the first 28 days following their birth. And this entitlement will be up to 12 weeks of paid leave, in addition to other leave entitlements. So payment will be made at statutory rate, which has been, I believe, set out as being £187, £18 per week. So it will become a day 1 right to take neonatal leave. And it will be available to those, the payment will be available to those who meet continuity of service requirements and have a minimum earnings threshold. So whilst employees may be able to take the leave, you may find that they don't actually qualify for the statutory neonatal care pay. So that would be something that you would need to look at as and when at the time. The concept behind the leave is that it will be tagged on to the end of maternity or paternity leave, and it will last as long as the child was receiving treatment capped at 12 weeks. So if the baby was in hospital for 7 weeks, as an example, then that will be tagged on to the end of the existing maternity or paternity leave that your employee is taking. And whether they will be eligible for pay or not will, again, depend on whether they meet those continuity of service thresholds. The care will be split into 3 categories as to whether any employee qualifies. and it will look at whether any medical care was received in hospital, whether medical care was received elsewhere, if the child was discharged from hospital, if they've had an inpatient stay and so on, and they are still being cared for under the direction of a consultant and so on, and being monitored. And also, sadly, in the case of where it's necessary to implement end-of-life care. In terms of what these various leave types will mean for the business, there may be an increased cost to your business if you are just paying statutory rates. In relation to the sick pay that I mentioned, in terms of that becoming a day one right at some point this year, of course, it may mean more sickness absence for your business. We anticipate that maybe in the hospitality and retail sectors, we may see more increased costs there, because typically those industries may normally just pay statutory sick pay. So we may find that, you know, they are paying out from day one, as an example, and become eligible for the payment where it would have been unpaid before. But typically speaking, companies and other industries may already pay company sick pay on a discretionary basis or as per enhanced policy. So on a sick level, we're not sure it will really make too much of a difference for those sorts of businesses. But what you can be doing now, you can be updating your leave policies in line with the new changes. And of course, think about whether you will be paying enhanced payment rather than statutory rates for the different types of leave types that are being introduced. Prepare your payroll systems for changes. Think about how you're going to document these leave types. So this is quite a big one for our clients. We do consistently see that a lot of our clients don't necessarily have a tracking system for absence that maybe works for the UK legislation. Maybe you have something for the home country, but not necessarily for the UK. So you need to make sure that you have a way of recording and having accurate records for future evidence and for payroll processing. Of course, we've talked about this a lot today, but informing and training your managers on changes. And then lastly, thinking about the changes coming in for bereavement leave and neonatal leave. Also consider beyond the actual payment side of things, what you can maybe incorporate as part of a policy. You know, are you thinking about the support that your employees might be needing when they take this sort of leave? Because, you know, it can be a distressing time in your employees' lives. So do you have any EAP or counselling services that you're able to offer as well as part of your company policy? I'll pass over to Helen to talk to you about 0 hours.
Thanks, Jacqui. The next section we want to talk about are 0 hour contracts and a recap on what we currently have in place and what the proposed changes are going forward. So currently, companies can use 0 hour contracts. This means that you don't have to guarantee any minimum hours of work. It's about the company offering those hours and the worker accepting those hours. So it provides a lot of flexibility for both employees and so the workers and the companies involved. But again, there's going to be big changes in terms of what this means going forward. So going forward, there will be penalties in place if you have planned shifts in place and then they get cancelled or rearranged at short notice. You will need to give compensation to those workers. You need to have a look at guaranteeing hours. So do you have people working already who work consistently and should be moved to guaranteed hour contracts? And you will need to be giving your workers advance notice of their shifts to be able to provide more stability. So the government have gone out on consultation on this piece, and they're really looking at moving forward in terms of putting more legislation and more protections in place for workers in this area. So going forward, what this means that you can do right now is to review the current contracts and shift patterns that you have in place. So are those on 0 hours truly working 0 hours, or are they working consistently a number of hours each week? And if that is the case, you need to think about moving them to a different contractual arrangement. And for those that are working consistently, looking at fixed hour contracts or on a fixed term contract basis, you need to think about how you're tracking your shifts. So again, you need to be giving people going forward prior knowledge of the shifts that you're expecting them to do, and have you got an efficient tool in place to help the business do that. We're expecting that there will be additional costs for compensating cancelled shifts, and there might be a possible increase in employment tribunal cases because there are lots of changes happening. And a very recent development, this was announced in the last week or so, that this change will include agency workers. So if you have agency workers, it will apply to them, and we're expecting the agencies to pass on additional costs to the end clients. So if you have agency workers in place and you have a scheduled shift for them, you cancel that at last minute, it's expected that the agency will pass on the cost that they have to pay to the worker onto you. So we're expecting an increase in costs around this as well. So it's important to have a look at your cohort at the moment. What hours are they working? Are they really truly 0-hour workers, or do you need to move them on to a different kind of contractual arrangement? And I'll pass over to Jacqui about fire and rehire.
Okay. So for those of you who aren't familiar with what fire and rehire is, this is where an employer dismisses employees and then offers to re-engage them on new, mostly less favourable terms, as a result of their employees having refused to accept proposed contractual changes. So currently, this isn't illegal, but it is super contentious. It's been very heavily criticised. There have been a lot of larger, well-known brands that have been in the press for negative reasons for imposing these sorts of changes on their employees, kind of strong-arming them into accepting less favourable terms. So we don't have a date yet on when the changes will be made, but the Employment Rights Bill will make it automatically unfair to dismiss an employee for refusing a contract variation. This will look at if the principal reason for dismissal is either that the employee refused to agree to a variation of contract that was being forced on them by the employer, or if this enables the employer to recruit someone else or rehire the employee under new terms, but they have substantially the same duties. So Helen was talking about unfair dismissal a bit earlier. Do you remember that the 2-year window will be gone like next year once this change to fire and rehire also comes into force? So there will be limited exceptions where an employer can demonstrate that it is in dire financial straits, it's about to collapse, and in that case then fire and rehire would be an essential exercise, but that is going to be super narrow exception. You won't be able to generally rely on that rule to be able to impose fire and rehire. What does that actually mean for you? Of course, if you were so inclined to go down that route to strong arm your employees, then you may find that there is an increase in unfair dismissal claims being made, and tribunals may look to impose financial penalties for non-compliance to companies. There will likely be a greater administrative burden because, of course, it will be necessary to put proper consultation processes in place, document the rationale for the changes being suggested, and trying to reach an agreement with employees. It's going to be time consuming, right, to make sure that consultations are run properly. But it's what you're going to need to have to do. So practical steps for this mean that you're best placed to engage early with your employees, communicate transparently with them. Look at your contractual clauses that you have in place now. So is there some flexibility in changing terms with reasonable time limits in there? Are your policies up to date? You really are best placed to speak to a legal advisor if you are looking to make significant contractual changes. And of course, equip your management, train them so that they have the appropriate negotiation skills to be able to handle those consultations. Because, you know, ultimately you need to treat your employees like humans, okay? Like, which might seem commonsensical, but you know, if your employees understand the rationale behind wanting to, needing to make these changes, and if they feel that you've treated them in a fair manner, in a respectful way, and if they feel that those changes are more aligned with the values of the business, there is an improved chance of being able to make an agreement with those persons to move on to the T's and C's that you want them to hold. But yeah, there will be some major changes in that respect. I'll move back to Helen to talk about trade unions.
Thanks, Jacqui. And this is very quite a brief section, but just wanted to recap in terms of the changes that are happening in terms of T's and C's and trade union representation going forward. So just briefly, at the moment, outside of the public sector, trade union membership is very, very low in the UK. It's quite unusual for someone to bring a trade union rep to a meeting or to have trade union representation outside of the public sector. Excuse me. But going forward, again, there are going to be significant changes. So there will need to be details put into a written statement of particulars to include the rights to join a trade union. So that has to go into an employment contract going forward. Again, we don't have a set date for this, but we know that it's going to be coming. Trade union reps will have a right to communicate with employees in the workplace, and that's not just in person being physically present. They will have the right to have digital access to your employees too. The trade union reps themselves will have stronger legal protections from unfair treatment, dismissal or victimisation from employers. And as I say, at the moment, it's a relatively low uptake in terms of trade union membership across sectors, across private sectors, but we are expecting that to shift and change going forward. So I think that the key things to think about at the moment is you'll need to review your contracts when the change comes into effect. We'll let you know as soon as we know when that's going to happen. And there is an expectation that there will be an increase in trade union memberships and that reps will be coming along to more formal meetings. So expect that trade union reps will be present in grievances, disciplinaries, redundancy meetings. So we expect there to be a greater presence in those meetings going forward. And I'll pass back to Jacqui. Thanks.
So third-party harassment. So many of you would have heard from Helen and I talking about the changes that we saw last year in October for legislation changes around sexual harassment in the workplace. But for some years, employers have not been liable for third-party harassment. So that means harassment to their employees by people who aren't other employees within the company. So they could be customers, service users, suppliers, but not actually employees of the company. But Labour are now looking to reintroduce the third-party harassment back into the legislation for third-party harassment. So there will be direct liability for employers if they fail to take all reasonable steps to prevent harassment by third parties on their workforce. So that is a change in wording, which has moved from reasonable steps to all reasonable steps, which is quite significant, really. So implications for the business. In terms of what you are meant to be doing, you need to look at carrying out risk assessments to see where your red flags are for the business. Having up-to-date policies on bullying and harassment, having clear processes in place for reporting and handling complaints, Of course, training. I know Helen and I have been speaking about the necessity to have training for your employees, not just to know how they should be conducting themselves, but also where to identify if they are the recipient of bullying or harassing behaviours, and what they maybe witness when they should be reporting these things. Practical steps. Of course, I did mention that there will be a necessity to take all reasonable steps, but think about your clear processes. Make sure that you actually have those in place, that you have a visible policy. And yeah, I've mentioned training. I just feel like I'm repeating myself now, so I'll hand back to myself for immigration. Okay. So the next step for immigration changes, for those of you who do sponsor employees in the UK, you will be aware that you are already paying the Home Office various immigration fees, and that includes a cost for a certificate of sponsorship. So we are expecting, again, sometime in spring, so the Home Office can really flex what they consider spring to be. But where you are purchasing certificates of sponsorship under the skilled worker route, they currently cost you an amount of £239 per certificate of sponsorship today. And that will be increasing to £525 per certificate of sponsorship per immigrant worker. So that's quite a shift. It's more than doubling the cost there. And then we also have the electronic travel authorisation, the ETA. So we have raised this topic on previous webinars, and I know that we have sent some mailers out to clients as well, and when we've been speaking to our clients, alerting them to this change that's coming in. But the Home Office have introduced an ESTA-like system, so an ESTA like you have for the US, for the UK, where all persons who are looking to visit the UK who don't already have another means of entry, of gaining right to entry the UK, so if they don't have a British passport and an Irish passport, or they're not under the settlement scheme, or they're not receiving sponsorship and have a visa or sort of work visa or dependent visa, anyone else that's looking to come to the UK, whether that be on a tourist route or just for a business meeting, will need to have an ETA prior to travel. So it can take around 3 days for processing. There is that caveat on UK Gov website to say that occasionally this may take longer. The ETA is linked to your current passport, and it lasts for 2 years. But if your passport expires within that 2-year period, then you must reapply. And the ETA will cost you £10 for that 2-year period. So you don't need to apply each and every time you travel. You just need to have an existing valid ETA that's linked to your passport. But if you do have any business trips planned, do please make sure that you factor in that you will need this ETA, otherwise you will be refused entry, or you probably won't be able to board the plane in the home country. Yeah, so